So, as Fred said, I'm going to speak to you about different ways that you as individuals can contract with companies. The first way that you can do that is via a service company, which would be a limited personal service company, or you could do it directly as an individual, or you may do it as a fixed term employee or worker, and that could possibly be under a 0 hours contract. We've just heard from Chris about how those different types of contract would work from a tax perspective, and I'm not going to make any recommendations as to which type of contract you may elect to use. I'm just going to give you an overview of what you might expect to find in a contract when you're given it by a company. So we're going to look at some key clauses that you might expect to see or might want to see in a contract. The first clause may seem an obvious one, but you want to make sure that the parties to the contract are correct. You want to, depending on the type of arrangement that you've entered into with the company, whether that is as an individual, whether you want to see the personal service company, the limited company as an intermediary, or and you also want to ensure that the client or end user or the employer is correct as well. It's important that you make sure that that is correct, particularly whether it's a limited company or you contracting as an individual. You as individuals would also want to ensure that the obligations that you've got to carry out under the contract are correct. The job description, the scope of the project that you're working on needs to be clearly defined in the contract from the outset so that everybody has clarity as to expectations going forwards. Similarly, you'd want to make sure that the hours of work under the contract are set out. You want to establish the boundaries of working time and when you may be expected to be available to the end user or to your employer. Would you be expected to work flexible hours? Are you expected to work strict office hours or core office hours? And can you be expected to be available outside of those hours as well? Another thing that the contract would cover is your place of work. Many of you will be remote workers, but it may be that the end user or employer expects you to attend their office for certain events such as training, appraisals, disciplinary issues, client meetings, team meetings, and things like that. You'd also want to ensure that the payment clause is in the contract that you're being presented with. You want to make sure that the amount of pay is set out in there, and whether that's an amount per hour, day, week or month, or whether it's a set amount for the completion of the project. You'd also want to make sure that it's clear as to whether that is inclusive or exclusive of VAT, and you'd also need to know if you need to produce an invoice or whether they're just going to pay that amount every week, day, month. You also might see an expenses clause in a contract that you're presented with. Self-employed workers, freelancers, consultants, would usually expect to pay most of their working expenses themselves, and that is something that would indicate self-employed status rather than employed status. It might be slightly different if you are being asked to travel up north for a set client meeting or pitch or something like that, that you would only be doing if for work on this project. You might be able to claim back expenses for that, but things like your day-to-day running of the business, your laptop expenses, things like that, as a freelancer, you'd expect to cover yourself normally. Remote employed workers would be slightly different, and those workers might be able to claim things like travel expenses to the office if they are being asked to go in for client meetings or training, possibly telephone costs, internet costs, even heating and lighting if you're working from home as a remote employed worker, and any increased insurance premiums. So there's quite a difference there between self-employed people and employed remote workers. Something else to consider is access to admin support. As freelancers and remote workers, what access do you have to admin support if that's something that you need, and at whose expense is that? That's something to make sure that you have set out from the outset of the contract and included, especially if it's important to the way you work. Something that Chris mentioned is a substitute clause. Consultants and freelancers usually have the ability to appoint a substitute to carry out work in their place in the event that they cannot carry it out personally. This is something that would be considered in determining your employment status by a court or tribunal, but by no means is it completely indicative. A court or tribunal would look at all of these things in the round and a number of different things to consider whether they would deem you to be a self-employed person or an employed person or worker. The other thing to point out in relation to a substitute clause is that it's all very well having that in the contract and saying, therefore it makes me a self-employed person. That's not the case. It's the reality of the situation that a court or tribunal would consider. And if in reality you would never use a substitute clause, because as Chris said, that relationship is between you and the end user, and it's your unique skill set that they need, then there's no real point in having a substitute clause in the contract, and it may then be possible that it's not included in your specific contract. You need to think about your individual situation when considering whether a substitute clause should be included. Something that you may be presented with when you are given a contract from an end user or employer is restrictive covenants. Companies may seek to impose restrictive covenants to restrict your activity once the agreement has ended. They want to do that to protect their confidential information and their clients and contacts. There is some scope for you to potentially negotiate any restrictive covenants that are in a contract you're presented with, and the way that you could potentially negotiate them are in relation to the length of the time that they apply, whether that be kind of 3, 6, 12 months after the termination of your contract, the geographical area that they apply to, or maybe even the industry that they apply to. So there is some possible scope for you to negotiate any restrictive covenants you're presented with. Similarly to that, a company may want to restrict what you're doing whilst you're actually contracted to work for them as well. Most of you as freelancers may be working on a number of different projects at one time, and a company may want to restrict you, and it's probably more reasonable for them to try and restrict you from working for a competitor of theirs at the same time as working for them. But depending on, again, your individual circumstances, that's something that you may want to push back on if you are working on a number of different projects, if that's something the company is seeking. Intellectual property is one of the areas where it's particularly advisable to set out the agreed position at the outset of a contractual relationship. And I say that because it's often an area of dispute if things aren't set out clearly at the beginning. Depending on the nature of the services provided, it would not be unreasonable for a company to keep the intellectual property rights in relation to anything that you're producing for them. Having said that, you may want to stipulate that the company does not have any intellectual property rights over the work that you carry out outside of the contract. Like I say, you might be working on a number of different things at one time. Or if appropriate, there may be scope to push back on retaining some or all of the intellectual property rights in the work that you are producing for the end user. That's something for you to consider and discuss with the end user or your employer. Chris spoke about different types of insurance that you may need, and usually we would expect self-employed workers to take responsibility for their own insurance premiums, and again this would be an indicator of self-employed status rather than employed status. For remote employed workers, it would be more usual for the employer to cover the costs of some of their insurance premiums, because again that's indicative of an employed relationship rather than a self-employed relationship. You'd also expect to see termination provisions in any contract that you are provided with. Often, as is the case with most of these things, the contracts are drafted from an employer's or end user's point of view. So the termination provisions would consider when they may want to terminate your contract, but it's important for you to consider any circumstances in which you might want to terminate the contract and make sure that they are covered off in the contract as well. If you're working abroad, which some of your questions indicated that you may be, or providing services to a company that's based or operating abroad, it is advisable to state that any disputes would be dealt with by the laws of England and Wales or the courts of England and Wales, or whichever jurisdiction it is and laws that you would like to apply to the contract. That's because if there is any disputes about the contract or the work that you've been doing later on down the line, you will need to know where and which laws are going to apply. Another standard clause that you'd expect to see is an entire agreement clause. It is often the case that conversations about contract terms happen in a very informal manner at the outset of a relationship. That might be kind of verbal conversations, emails about what's going to happen, the work that you're going to do, the rate of pay that you're going to receive, and the hours that you're going to do that over. If you then sign a contract that includes an entire agreement clause, all of those conversations would be superseded by the contract itself. So it's absolutely vital that you ensure that all of the key terms, or all of the terms, are included in that contract as you understand them to be, because anything in those emails or conversations would otherwise be superseded. I think I've said this already, but the inclusion of these clauses alone would not be indicative. You can't just say there's a substitute clause, I sometimes send a substitute, so therefore I'm a self-employed person. That's just one element that a court or tribunal would consider in making a decision. And the things that they base their decision on would vary slightly from what Chris was going through that HMRC consider. It's important to remember as well that it's the reality of the situation that courts or tribunals would consider, and not just what's necessarily in the contract. You can't get out of things by just putting them in the contract if that's not what is actually happening. We would advise, for all the reasons that I've been through, that you would have all of the terms agreed in writing from the outset of the contract. It just really helps further down the line with having clarity for everybody know what the expectations are, and if there are any disputes then you can look to the contract and have everything hopefully clearly written there, so you can refer back to that. And that's the end. Does anybody have any questions?